Hi, everybody. My name is Michael Brady. I'm a partner at Warner Norcross and Judd, and I'm here with my partner, friend, and colleague, Laura Yu. Laura, how are
Thanks,
you?
Michael. I'm good. Thank you.
We are so excited to be here today. This is our very first podcast in a series of podcasts. We're calling it Supplier Side, Legal Insights for the Automotive Supply Chain. And Laura, you and I are in the trenches every day. We
That's
represent
right.
suppliers all day, every day at Warner. And one of the questions that we get a lot is what is involved in a lawsuit? And what does it mean to go to court, so to speak? What does that entail? What are the costs? When do you do it? When do you not do it? And unfortunately, we've seen our clients have to deal with this over the years, especially with all the different stresses and strains in the automotive supply chain. So we thought we'd talk for a minute about what that means.
Yeah, I think common issue, right? And hopefully you never get there, but sometimes you have to. And the point of this conversation is just to pull back the curtain a little bit on a high level overview of the process and allow us to give some of our insights along the way. So I guess before the word lawsuit even is discussed or comes out, how do you see, or what are some early signs you get that a dispute is headed towards litigation?
Yeah, it's a great question, and it's not always obvious for our clients to see it because they're just in the trenches again when working through the business issues. But what we see oftentimes when our clients bring us in is there's a change in tone in the communications. Everybody communicates by email, but when it goes from collaborative, how do we solve this problem, to people taking positions, when the language changes,
Yeah.
when Sally or Sue, who's not a lawyer on the other side, all of a sudden starts referring to the Uniform Commercial Code.
Using some legalese.
Yes, demands for adequate
Mhm.
assurance. And you see sort of languages like that. The font might look different because somebody maybe ghost wrote it for them.
Like
So
cuts and pastes.
these are signs that things might be trending in a negative way. And obviously, we're talking about issues where it's not a $5,000 dispute, but it's a supply chain disruption. Somebody's threatening to stop shipping, or there's a big warranty matter where it's tens of millions of dollars at stake. When you have those issues, those don't just go away typically. So you see that trending toward potential litigation. And and along those lines, Laura, what I want to ask you is we've done this a lot. We've seen the good and the bad. Before a lawsuit's mentioned, when there's just negotiations going back and forth, what are the biggest mistakes that you see that clients make?
Well, I guess mistakes where things go wrong is not involving outside counsel early enough, not getting us involved. And listen, uh, by all means, there's no doubt that your commercial teams are the best suited to resolve the issue. They know the history, they know the product, they know the program, they know the pricing structure. And I'm not suggesting that we get involved to replace those conversations or replace the commercial team, unless that's what you want, unless it's time for that to happen. But what I'm suggesting is get outside counsel involved to assess the contract and the legal position that you're trying to take, that you'd like to take, so you know whether it's viable, so that we have some of the history too, so that we can guide some of the communications, and so that we're ready if the dispute escalates quickly. That's what I'm here for, and that's why I suggest we get involved early.
So not to get in the way, but be part
Absolutely
of the team.
not. Yeah, lawyers can sometimes get in the way, right,
Yeah.
of productive commercial discussions, and that's not what we want to do. We just want to be there in case things escalate. That's not a place where you want to be like caught on your heels, right? These are high stakes disputes, as you say. So it's important to know what your position is and feel confident in it.
Mm-hmm. So let's say you start to get the nasty grams in the emails, and you can definitely see things are ratcheting up. And let's say that the supplier gets a notice from their supplier saying, "Hey, we're going to stop shipment in 30 days unless we get a price increase because our costs have gone up because of tariffs, because of inflationary costs because of labor costs, the kinds of things that we always see. And so the word lawsuit maybe does get mentioned then.
Yeah.
Then what's the next step there? Where do we go from there?
I mean, it depends on some of the urgency, right? So 30 days is not the same as, next week, or we're not shipping ever again. So it depends. But what you might be describing is a situation where a temporary restraining order, that's a TRO, we call it, might be necessary or useful. And that's just, an emergency order from a court compelling continued shipments. So that might be something that you need. But this is, you're right, a high stakes situation, high stress. Things can escalate very quickly. And the legal stakes are high, but so are the commercial stakes, right? So if you've got somebody, a supplier who's not shipping, that means you're not going to be able to ship to your customers. This is a supply chain, right?
Hmm.
And not only might that get you into some legal trouble, contractual trouble with your customer, but it also damages the relationship. So that's why it's great to have outside counsel involved early, because we can be there, we can handle it, take it off your hands for you. But yeah, with or without outside counsel involved, this is something where you're asking yourself, what's next? Where do I even start with this analysis when I get a letter like this?
Hmm. Yeah, and that's where we have found we can jump in
Mhm.
and help.
Hopefully we're already in, right?
Hopefully we're already in. At some point you got to bring in outside
Yeah.
counsel when threats of lawsuits or threats of supply chain shipping stoppages start. And what we can do, because in our humble opinion, we think we really know the automotive industry. We
We
can
do.
we can jump in, and we know your business, we know your industry, we know what the acronyms mean. You don't have to explain
Hmm.
what PPAP means to us. For example, we can jump in, we can analyze the contracts, analyze the legal issues, the factual issues, and typically you got to do that on a pretty fast basis, right?
Yeah,
If you're thinking about going into court, I know you like to tell clients I can get into court in a day or two, right, Laura?
it's the truth. I can do it.
and sometimes you don't have a choice.
Yeah.
Sometimes, and this is, I think, goes to your point about getting us in or outside counsel in early and often, is there might be a situation where you start to look at the correspondence and it's been a problem that's just been going on for months,
Yeah.
and we don't get brought in until the 11th hour, and we can move quickly, but filing a TRO is not like pushing a button. There has to be a gathering of not just a legal assessment, but gathering of the internal facts, getting the documents, putting together a complaint, a persuasive affidavit, a motion for a temporary restraining order. These are all things
Mhm.
that we've done it before, but every single one is different. And the worst thing you can do, unfortunately, I don't think it's happened to you or me, but we've seen it from opposing counsel. The worst thing you can do is rush into court and say stuff that's wrong,
Yeah.
right? That just blows up in your face. You lose credibility with the court, with the other side, maybe with your own client. So you really need to make sure you go at a quick pace, but a pace that you can present a persuasive argument to a court to get a TRO.
Mhm.
But let's say you do all that, Laura. How long does it take? Is it you file and then an hour later you get a TRO? What's the process like?
So it really depends on the court that you're filing in, and a specific judge. So unfortunately, there's no set standard or guidebook that I could provide. But it's really your filing. The sooner you have the information, as you say, from the client, the better. The more prepared you are, and then once you get in, it could take. I've seen same day TROs be issued without a hearing. But that's really a question of the judge's availability and their preference for holding a hearing in advance of issuing a TRO. It's dependent on a lot of factors, but I say it could be within 24 hours to 48 hours. Typically, we'll have heard something from the court one way or another.
Hmm. And that's just the initial temporary restraining order, which
Hmm.
expires after 2 weeks. And then you got
Hmm.
to get a preliminary injunction, and all these things take time and effort and attention from the business team. But sometimes it's necessary if you've tried everything and the other side, in my hypothetical, just won't ship parts without a
Yeah.
price increase that they're not entitled to. Um, but to go to court, some clients, some suppliers forget that you're filing a lawsuit,
Yeah.
right?
Mhm.
You're not just, okay, I'm going to be in court for a couple weeks and then I'm going to be done. That could be the case, but you've also got to file a complaint. You've got to bring causes of action against the other side, breach of contract, um, um, permanent injunctions, those kinds of
Mhm.
claims. And so let's say you get an injunction. Does the case stop then?
No, and that's one of the things that surprises clients, right? Is that, you've got this TRO that you secure. The court says yes, supplier must continue shipping parts. And then, as you mentioned, within 14 days, because that order is temporary, it's in the name, temporary restraining order, right? Um, there's a preliminary injunction hearing to determine whether the TRO will continue throughout the pendency of the underlying litigation. So this is all happening within a 2-week process. Things are moving very quickly. It can feel like a fire drill for somebody who's not used to it. It's a huge lift. And you could win on both counts, TRO, preliminary injunction, but you're not at the end. You're at the beginning. And that's a huge surprise to many clients. Um, Otherwise, if you go into court, it's not an emergency situation. You're just filing a complaint. Um, the outset of a lawsuit can be very, I don't want to say boring, but it is very procedurally heavy. You're filing an answer to the complaint or a motion to dismiss. You are going to court for a case management conference with the judge. That's just attorneys, but judge wants a flavor for the case, wants to know if early settlement might be possible. And then you're setting, deadlines for the remainder of the litigation. How long will discovery be? Um, when will trial be? Those sorts of things. How long do you need for trial? Um, and then on the other hand, what the client is doing is sending out document preservation notices
Mhm.
and kind of identifying for us who the key players are in the dispute, who the key custodians are that might have these documents, interviewing them. And that is an operational burden, right? That I think
Mhm.
surprises clients that at the outset, although there might not be a lot going on in court, there's a huge operational burden
Sure.
at the business level.
Sure. And everybody's heard horror stories about e-discovery and
Mm-hmm.
thousands of documents. We have an e-discovery team. We try
Yeah.
to work through that efficiently, but it still costs time and money. And everything you're describing in terms of the beginning of a lawsuit to a potential trial, that could be 2 years down the road, right?
Yeah, absolutely.
Um, and we're going through, let's say we're going through this piece of litigation. We're dealing with document production, depositions, court hearings, motions to compel. What's a client, what's a party to the case? What are they seeing? Are they involved in this? Are they just taking a step back and letting the lawyers take over everything? What do you see when you litigate a matter?
So, what I would prefer is to have, a single point person or point people who are at the company and who are knowledgeable, can get me to the internal team that I need to talk to in order for, fact development. Um, but, you know, it does cause a bit of a business disruption because I'm asking you to collect documents and we can have people who can help you do that. But there's also just time away from the business, the work of the business, right? Because you're collecting those documents for me, you're answering my questions. If they come up, that's why it's helpful to have just one person who's talking to me.
Mm-hmm.
Um, and there might be people in the business that need to be deposed. They're going to be taking time away, not only to attend their deposition, but to prepare for their deposition. So these are all sort of the calculus that you go into when you decide whether it's worthwhile to enter into a lawsuit.
Yeah. Yep, definitely. It's so key to have the point person internally that can
Yeah.
help guide things. And all of these topics we could take hours to talk
Oh my
about.
gosh.
We're happy to follow up
Absolutely.
with anybody who's heard anything that we've talked about here that they want to hear more about. But as a takeaway, I'm curious what you think, Laura. But from my perspective, the key for getting into litigation and then hopefully getting out of litigation, either through a trial or some sort of settlement along the way, is identifying what your goals are
Yeah.
with your legal team, with your business team. Why are we going to court? Why are we filing a lawsuit or defending a lawsuit? What do we want to get out of it? And then working hand in hand to efficiently achieve that goal.
Hmm.
And that's what we take pride in, right, in terms of representing our supplier clients. But what would you say is your key takeaway as we leave here today?
Well, I think knowing what your goals are, what the merits of your case are, and what's at stake. Not every dispute is going to be worth taking to litigation, but you've got to kind of do that calculus, and we can help you do that. It's also important to note that there's a lot of off ramps in litigation, and again, a whole podcast could be about timing and where those off ramps are and how to structure it strategically. But knowing what your goals are and whether this is going to be a worthwhile pursuit, absolutely.
Great. Well, it's been great talking to you.
You
This
too.
has been a lot of fun. It went fast, but this is our first podcast from the supplier side.
Mhm.
We look forward to doing many more with other members of our automotive industry group team. And with there, we'll stop it. Laura, let's
All
get
right.
back to work.